Well, every Friday we are joined by Colorado's best attorney, Phil Harding, who is our legal expert, and he always teaches us about different areas of the law. Today, he's going to be walking us through some of the court jargon that we hear a lot, but maybe wonder about, and also all the different levels of court. But Phil, first you were telling me that you answer our viewers' questions all the time on Facebook and our website, and you got a really interesting post this morning.
I did. I'm happy to go over this and talk a little bit about it, but I'm talking to viewers and Facebook friends and finding out what they want to hear about. And here's a direct quote of what someone said. They said, "We want honesty and integrity like lawyers of the old days." And you know what? That's true. I think attorneys have a really bad rap right now. But I want our viewers to know this. First of all, attorneys are officers of the court, which means they can't lie to you. They can't lie to a court. They can't even put on testimony that they know is untruthful. Number two is they owe a fiduciary duty to clients, which means they have to act solely for their best interest. So I think we as a society really need to demand from our lawyers to be ethical and make sure if someone's lying, that's a problem.
Yeah.
They shouldn't do that.
Hold them accountable. Absolutely. Right. Okay, that's a great point. Now, talking about the jargon, you hear a lot of different things, especially with the law shows, and you hear the words, plaintiff and defendant. But kind of walk us through exactly what is a plaintiff.
Right. Well, we're going to go over a bunch of stuff, and I think we're going to like it. Let's look at this. We have a graphic. First of all, a plaintiff is the person who starts the lawsuit. They're also known as a petitioner. Now, the person who appeals, which could be either the plaintiff or the defendant, is known as the appellant, and the person who is defending the appeal is known as the appellee. So the defendant, again, is the person who's being sued. That's also known as the respondent.
Okay. So, the defendant one always, made sense to me. Okay, you're going to defend yourself.
Exactly.
But the plaintiff one, it's always, nice to hear kind of that definition. Okay, so let's talk about the different levels of court. So there's so many different levels that you go through.
And we're talking here about the civil arena. And there are three different levels really to start off with. And the first one is the small claims court. And let's talk a little bit about this. The small claims court is really made for individuals to resolve their differences quickly. There's a limit of $7,500. So even if someone has, you're claiming $30,000, you can still bring that in small claims court, but the maximum you can get is $7,500.
Okay, that's the ceiling.
That's the ceiling.
Okay.
This court is really designed to have nights and weekends because they know it's a court for the people. And because of that, there are no attorneys allowed in there. If you have an attorney, you can't go to small claims court. There's no discovery allowed. And let me tell you what discovery is. That's depositions. And remember, a deposition is where you sit someone down in front of a court reporter, you swear them in, and it's just like doing testimony, but you do it beforehand. You can't do written discovery, which are called also interrogatories.
Okay.
So
no attorneys, no discovery.
No discovery, and the magistrate there is going to make an immediate decision as to who's right, who's wrong.
And whatever they decide, that's it. It's done.
That's it. Well, and we're going to talk about appeals if you don't like that. But the next level is county court above from the small claims action. And let's talk a little bit about, or more about this county court. County court, now the jurisdictional limit is twice that of small claims. It's $15,000.
Okay.
Attorneys are allowed, and now you can have a trial either through the judge or a jury, and that's chosen either by the plaintiff or the defendant.
So they can decide if they want to just have a judge or a jury. Okay.
And if the plaintiff says, I want it by a judge, and the defendant comes in and says, no, I want it by a jury, they can choose that. You have to file an answer, the defendant, and then there's a court date set, and it's usually months out. And then these judges can either give you an immediate decision, or they can give you a written decision a couple weeks out.
Okay. And then the next step up from there, from county court, is going to be district?
It's district court, that's right. So district court has what's known as unlimited jurisdiction. And that means you can sue for anything from no dollars, which means you just want an action to be taken, or billions of dollars. Trials are usually scheduled a year or more out. Now there is that pre-discovery that's allowed. Written discovery, those interrogatories, depositions, motions are usually filed, and this is the highest level right now of just the trial courts.
Okay. So, we were talking about appeals a little bit earlier. I was thinking like in small claims, once the judge makes a decision or the magistrate that it's done, can you appeal at every level, whatever decision is made?
You can. You're entitled to, and let's talk a little bit about appeals. Generally, there's a very short time frame that you can file what's known as a notice of appeal. The appellate court only reviews the information presented at the lower court. And everyone gets this wrong. There is no new evidence presented. So even if you have the smoking gun, you cannot bring that in
Really?
unless the lower court looks at this. And we have a graphic here, so let's talk about this. To small claims court, you go up to county court for an appeal, county to district, district to the Court of Appeals, and the Court of Appeals, if you don't like that decision, it goes up to the Supreme Court. Remember, you're only allowed one appeal by right. Any other appeal, like if you were in district court, went up to the Court of Appeals, you don't like that decision, you have to file what's known as a writ of cert, where you're asking permission for a higher level court to look over this, and it's rarely granted.
Incredible. All right. Well, that that clears it up a little bit more for us. I mean, clearly we still need an attorney, but it is nice to have the definitions for us this morning. We appreciate it. And if you have any questions for Phil, just like the person who Facebooked you today, just go to our website, coloradosbest.tv, send him your questions or your comments, and often he addresses them right here on the air, and he also answers all of your questions personally. And if you would like to contact Phil at his office, Harding & Associates, you can call him directly at 303-762-9500. You can get a free consultation anytime, and you can find him online at hlaw.org. Well, coming up on Colorado's Best, it is National Wear Red Day, and prevention is happening.